I am Javier Rivera Carbone, Workplace Attorney Investigator, and I welcome you to the Labor and Employment Law section of the Orange County Bar Association monthly key case updates for the cases published during June 2025. We will review the cases, discuss their practical implication as a matter of policy and in litigation. The case update presenters for this month are Xinye Liu and Mimi On. Xinye Liu is an associate at Workplace Justice Advocates, where she concentrates her practice in representing employees. She is part of a team that has a record of getting big verdicts for employers. Mimi On is a partner at Kahana Feld, where she is the chair of the Labor and Employment Law Practice Group, and she concentrates her practice in representing employers in the full spectrum of issues and legal issues that happen at work. Xinye, Mimi, please go ahead.
Thank you. Thank you, Javier. The first case we are presenting today is Ames versus the Ohio Department of Youth Services, cited as 145 SCT 1540, decided on June 5th, 2025. This is a very interesting case, I think. The Supreme Court issued a unanimous 9-0 decision holding that Title VII protects all individuals from discrimination based on a protected class, regardless of whether the individual is part of a majority or minority group. The court reaffirmed that McDonnell-Douglas burden shifting framework applies equally to all plaintiffs. So the fact of the case is this: the plaintiff Marlene Ames, a heterosexual woman, was employed by the Ohio Department of Youth Services as an executive secretary. She was later promoted to program administrator and eventually applied for a newly created management position. Although she was interviewed, the agency ultimately selected another candidate, who is a lesbian woman. Shortly after her interview, Plaintiff Ames was removed from her program administrator position and demoted back to her original secretary position. The agency then hired a gay man to fill the program administrator position. Plaintiff Ames subsequently filed a lawsuit under Title VII, alleging she was denied the promotion and demoted because of her sexual orientation. So at the district court level, the court concluded that she failed to establish a prima facie case of discrimination under the first step of the McDonnell-Douglas framework, reasoning that she had not shown background circumstances suggesting the agency was one of the rare employers that discriminates against the majority group members. And the Sixth Circuit affirmed the ruling, thereby deepening a circuit split on whether majority group plaintiffs face a different evidentiary burden under McDonnell-Douglas. The Supreme Court, however, reversed. It emphasized that Title VII's disparate treatment provision makes no distinction between majority and minority group plaintiffs. Congress intended to protect every individual, and nothing in the statute authorizes courts to impose additional burdens on majority group plaintiffs. The court rejected the Sixth Circuit's requirement that majority group plaintiffs must show background circumstances to establish a prima facie case. It found that the plaintiff's evidence, her qualifications, being passed over for a promotion in favor of a gay candidate, and later being demoted in favor of another gay candidate, was sufficient to satisfy the prima facie burden under the standard of McDonnell-Douglas framework. That's why the court reversed the appellate court's judgment and remanded the case for further proceedings. So, as a plaintiff's attorney, my takeaway in this case is that the Supreme Court made it crystal clear. Title VII's protections apply equally to all individuals, including those in majority groups. There is no second-class status under Title VII. Whether a person is gay or straight, male or female, black or white, discrimination is discrimination. This landmark ruling is expected to level the playing field and allow more, I think, reverse discrimination claims to survive early dismissal and proceed under the same evidentiary standards as the other Title VII claims. Now I would like to pass to Mimi to provide her perspective as a defense attorney.
Thank you, Shanu. I agree with you that this is a good reminder about Title VII's role of prohibiting workplace discrimination. And in light of this case, I think we may see more lawsuits being brought by the plaintiff's bar on behalf of majority kind of grouped plaintiffs. And so I would recommend to my clients that they should really reassess how they approach employment decisions, particularly when it comes to hiring and promoting. And it shouldn't be based on characteristics like sex. And maintain strong documentation to show what the reasons were for why they were hired or why they were promoted that does not include protected characteristics, and that can help mitigate potential exposure down the road. So the next case we wanted to discuss was Velarde versus Monroe Operations, LLC. This is a case where the plaintiff worked for a hospital or residential care center. They had required her to sign an arbitration as a condition of employment, which, as we all know, is not unusual. But here, the lower court and the appellate court found issues with enforcing this arbitration agreement because there was extensive evidence presented that this arbitration agreement was buried in a stack of 31 documents, and the plaintiff was asked to sign the documents as quickly as possible with, I believe, the HR manager just waiting there before she could start work that same day. What the Fourth District Court of Appeals found most problematic was that in response to questions by the plaintiff about the agreement and her stating she felt uncomfortable with the agreement, there were representations made to her that were false about the nature and the terms of the agreement. And not only were they false, they directly contradicted the actual terms of the agreement. And the court found that made the agreement substantively unconscionable, in addition to the procedural unconscionability based on this being an adhesive contract. Practical takeaways for this case is I do think that HR managers or whoever is presenting arbitration agreements to employees need to be trained on how to present these arbitration agreements, such that in the event this is an issue that comes out later, they are able to say and explain how they went through the arbitration agreement process with that employee, and they know what they should or should not say. Oftentimes we just tell employers, or employers oftentimes tells their employees, like, we just need to get this signed, have them sign it, and they don't understand the consequences of what could happen if they just lie to employees and tell them it's something when it's not. Shinyu, what did you think about this case?
Yeah, and I think this case is a sharp reminder to every employer that procedural conscionability or fairness is not just a box that employers can check with a signature. It should be real, meaningful, and transparent. And another thing I think in this case, plaintiff did something incredibly important. I wish every employee would do the same in this situation. She clearly told HR, I didn't understand the arbitration agreement and I don't feel comfortable signing it. that's the moment the employer had a legal and ethical obligation to step back and say, "You are right. Take your time, consult someone if you need to." But instead, the HR manager misrepresented the nature of the arbitration agreement, and plaintiffs as lay employees may not know what arbitration clause meant, but the courts knew it. And that's why the court found both procedural and substantive unconscionability in this case. And I think this case also affirmed that coercion disguised as efficiency is still coercion. What's so significant about this case is that the courts are paying attention to the real world dynamics of power in employment relationships, especially at the moment of hiring. This is particularly important for low wage immigrant and like first-time workers who are often intimidated by legal language and pressured by economic necessity. So I think this case definitely arms us with language and precedent that we can use in the future to challenge some oppressive arbitration agreements, not just because of their terms, but also because of how they are presented. Yeah, that's my 2 cents about this case. And but ultimately, I think this case reminds us arbitration may be legal, but it must be fair. And this leads to the next case I want to mention, Silva versus the cross-country healthcare, where in that case, arbitration is also deemed not fair because the employer sneakily carved out exceptions in a separate agreement. In this case, the California Court of Appeal reaffirmed that employers cannot use layered contract schemes to sidestep unconscionability law. The defendant had employees sign both on an arbitration agreement mandating arbitration for all employment claims, and a separate employment agreement that covered out exceptions for claims more likely to be brought by the employer, such as breach of confidentiality or competition. The court found that when read together, these agreements created a fundamentally one-sided dispute resolution system. Employees had to arbitrate their claims and pay their own legal fees, but the employer retained access to court, attorney's fees, and injunctive relief. The court held that such an arrangement was procedurally and substantively unconscionable and refused to enforce the arbitration agreement, even rejecting severance. So my perspective in this case is stacking contracts to favor employers at the expense of employee rights won't survive judicial scrutiny. And in the end, I want to quote to my favorite citation I use every time opposing a motion to compel. And this is in Armendariz Supreme Court found if the arbitration system established by the employer is indeed fair, then the employer as well as the employee should be willing to submit claims to arbitration.
Thank you, Sherry. So we're just going to do some honorable mentions of these cases, but my short takeaway for Silva is we see courts that are really looking critically, not just at the arbitration agreement, but how they work with other agreements and how they work in real life. So if you want an enforceable arbitration agreement, we really need to strongly recommend to our clients to not try and work the system. We have an enforceable agreement, great, we can enforce it. If they don't want to arbitrate later down the road, there are options to do that, but it's better to have an enforceable agreement than it is to kind of work the system and not have an enforceable agreement. The other case we wanted to do just an honorable mention of is Allison versus Dignity Health. That's a case where I would categorize that as a win for employers. The First District Court of Appeals held that essentially broad reliance on time clock data and expert surveys were not going to be sufficient to sustain class-wide liability and find certification on that. And the appellate court affirmed the trial court's ruling that the evidence provided by plaintiff was unreliable. It was a survey, and that it couldn't be remedied prior to trial because that survey was sent out to like 1,500 registered nurses, but only 218 nurses have responded. I think just the quick takeaway from that is this case illustrates you shouldn't just rely on time clock data and expert surveys to sustain class certification. You really need to go beyond that. Sherry, what did you think?
Thank you, Mimi. To be honest, I don't do any class actions, but I think in this case, certification is not the finish line in class actions. And I think another thing also applies to individual plaintiff cases. It's better for plaintiff's attorney, especially to have a constant theory of the case at the early stage of the case. Yeah.
Another month in California Court of Appeals. In this case, even the US Supreme Court, some good for employers, some good for employees. So thank you, Sherry. Thank you, Mimi, for your insights. Thank you for taking the time. And I want to invite everybody to our next in-person meeting where there's going to be a panel discussion in depth of insurance and insurance coverage in employment disputes. Also, big thanks to all the attorneys at Payne & Fears that prepared the case update summaries that you're getting today. And with that, we will see you next month. Thank you.
Yeah.